G'day troops, it's Maro here again, and today we're going to be discussing the case of Keith and the Alliance Group. This is a conversation about the necessity to obtain a medical certificate, and ultimately, the employer in this case is proven right. Long story short, Mr. Keith is an enclosed forklift driver in Oamaru. He has what we would loosely describe potentially as a pretty bad day. Knocks a few people potentially absent-mindedly in the shoulder as he walks about in the morning, has a small accident with another forklift on site, has a bit of a challenging discussion with another staff member, and ultimately, as his day progresses, I think we can safely say the plot thins. Mr. Keith, around about 3 o'clock, is invited into a conversation with his superiors, and the conversation sort of goes, I wasn't there, but I imagine it went something like, "Hey Keith, big fan of you and your work. Looks like today's not going super great. Seems like there might be some issues. Apparently there's also a conversation here with respect to mental health. But long story short, the employer says, brother, let's take a bit of a breather. We'd ask you to leave work, go get a medical certificate, just confirm for us that everything's okay, and come on, backsies." There is a conversation. He is asked his opinion in this respect. He agrees to go and get the medical certificate and ultimately does so. There is, of course, however, because it's a case, a claim of unjustified disadvantage, effectively saying he shouldn't have been asked to go through this process to leave the site and obtain the medical certificate. The courts have a bit of a look at this and basically says, look, on balance, there's a bit going on here. There are enough activities on the course of work day activity that suggests actually there's something here to think about. There's clearly an accident, although there's a drug test and it's not positive. In that sense, he's free of alcohol or drugs. It's still clear that there's an issue of some description that involves some consideration. As a result of that, the court effectively says it's not unreasonable for the employer acting from a health and safety perspective and a desire to be careful and to have a safe workplace to ask you to confirm the position and for you to go away and do so, especially when it's relatively quick, relatively simple, and no one's proposing to dock any pay or take any punitive actions as a result of that process. So folks, what I think that tells us is really simple. It tells us that in the event that there are unusual and potentially safety-connected circumstances in your site, it is possible for you to effectively say to an employee, hey look, bit of a timeout, probably a good idea for us just to get checked out, make sure everything's okay. That seems both an act of reasonableness and an act of care on behalf of an employer. Ladies and gentlemen, boys and girls, that's pretty much all she wrote for this particular case. Thank you for joining me as per always, and we'll see you again soon.